Bismillahirrahmanirrahim. Assalamualaikum and good evening. Welcome to today's forum. First of all, I would like to thank you to all panel in front of me. Thank you very much for attending the forum for today. Our issue that needs to be discussed is rule of OSHE legal requirement in business management and Occupational Safety and Health Act in Malaysia and its salient feature. Before we get into the topic, I would like to introduce our panel for today's forum. The first panel is Mr. Muhammad FITRI ZUHAIR bin AZMAN B0922100007. How are you feeling today, Mr.?
Yes, I'm okay.
Oh, good. Alright. So the next is our panel is Mr. Muhammad Daniel IQMAL bin Muhammad NAZRI B0922100347. How are you feeling today, sir? Sir, open the mic.
My bad.
Very good, very good. Oh, it's okay, sir. Oh, so funny, today. Oh, lama. So, well, the next panel is Mr. Abdul MOHAIMIN AFIQ bin SHAMSUL AMRI B0922101152. How are you feeling today, sir? Good?
Yeah, good. How about you?
Yes. So good. Good.
Alhamdulillah.
Alhamdulillah. Okay. Finally, we have Mr. Muhammad FARHAN IZZUDDIN bin Muhammad JAMIL B0922103767. Sorry. How are you feeling, sir, today?
Yeah, I'm good.
Yeah, good.
Thank you.
Alright. Last but not least, I am one Muhammad Akmal Azraei bin Wan NAZLI B0922100212 as the moderator of today's forum. We are proud to be here today to share and gain knowledge on the way OSHE management is implemented is very important. There are two act bonding all organizations in Malaysia in order to ensure the workers are being protected from all risks coming from the workplace hazard. So, Factory and Machinery 1967 and Occupational Safety and Health Act 1994, OSHA 1994. Regulation, guidelines and code of practice have been drawn up to support both acts. So I would like to start. So, our panel, good, right? Can we start right now?
Can.
Yes, Cam.
Yeah, right. So I would like to call first panel is Mr. Muhammad FITRI ZUHAIR bin AZMAN to share your knowledge about rules of OSHE legal requirement in business management. So, sir.
Good morning. Good evening, everyone. Thank you
evening,
for inviting me. Now we briefly explain from OSHA 1994, and we made a composition between Major and Germany. Okay, as mentioned, rules of OSHA in business instrument does not matter. Okay, so firstly, I will explain about the one of the session in OSHA. Listen, for which is section 20 part 5 from the OSHA 1947. The general duties of designers, manufacturers and suppliers. Okay, general duties of designer, manufacturers and also suppliers are clearly stated in OSHA 1994 under Part 5, Section 20, 21, 22 and 23. State clearly the duties that designers, manufacturers and suppliers have to employees, designers, manufacturers, importers or suppliers of plant or substance produced at work must ensure that so far as is practiced. Practicable, they will be safe and released out. When properly used, they must carry out all areas for the targeting of testing and estimation to ensure that the plants and substance are safe and without risk to help its site designers, manufacturers, importers or suppliers. Must also supply information about the use for which a plant or substance was designed or permanent and include any condition of use regarding its safety and wish to help in addition designers, manufacturers and suppliers. Plans and substance must carry out or arrange for the carrying out as well as this practice work of any necessary response to all minimize and wish to and help anyone who is false direct. Any personality use OK under section 23 of OSHE 1994 provides that a person who wins the provision of section 20 or 31 shall be guilty of an offence and shall on conviction reliable to a fine not exceeding 20,000 ringgit or to imprisonment for a term not exceeding 2 years. So for notification of accident dangerous, occurrence, occupational poisoning and occupational disease and inquiry is state in June 1994. Under section 23 to 3 and 34. Under this decision, it explained that an employee must notify the numerous occupational safety and health office of any accident dangerous occurrence, occupational poisoning or disease which has occurred or is likely to occur and the workplace every registered medical practitioner or medical officer attend to according to visit a patient who he believed to be suffering for occupational positioning of occupational disease. Interest title of the FITRI answer at 1967 or name in any regulation. Order made by Mr. under the Act must also report to the Director General. After I mention all this, now I will make a population between the Malaysia and Germany. First of all, I would like to highlight that safety and health in business management really matters. One of example is inform the German butchery, but the TV sector participating companies had their opinions reduced if they promote safety, for example, by buying knife or giving safety training to drivers. Okay, after that, they met one of these precautions by providing some safety equipment or having a safety business of this team result in 1,000 fewer reportable accident per year for the sector and for this sector battery in Germany. Secondly, a reduction in cost value at 40 million euros in 6 years and a saving of 4.81 euros for every euro invest for insurance. Free size tools can help to reduce the number of stability and cost of claim as I stated before. Not only those for poor safety and health costs, company's money but good. OSHE pays dividend business with high safety and health standard are more successful and more sustainable, as I mentioned. In the German, live in the Germany sector style is assuming that for every euro invest, there is a return of there is a return of and yield is favorable. Okay, the economic advantage of good Australia for business, large and small, are significant to give just a few examples. Good workplace safety and health must improve their workers. Productivity cuts down on absenteeism, reduce compensation payment, and lastly meets the requirement of public and private sector contractor. Okay, taking action could bring significant benefits for you. That's all from me. I pass to moderator.
Alright, thank you, Sir Muhammad FITRI ZUHAIR. Beside that, the objective of the Act of 1994 is to secure the safety, health, welfare on of person at work against risk to protect person at the place of food. So, other than a person at work against risk, which is the protect person of other person is maybe customer or contractor, and other than employer and employee of the company. Also, the object of the act is also to promote an occupational environment for person at work which is adapt to their psychology and psychological need, and to provide the means toward a legislative system based on regulation and industry code of practice in combination with the provision of the act. The section before maybe insert about section 20 to 24, and before that they have having a section 50 to 19, which is more to for the standard for employer and employee regarding that to ensure the worker or other persons such as customer or other employee itself are not affected and exposed to risk to their safety and health. Okay, that's the rules of OSH legal requirement in business management. So next, we want to know about business management, right? Daniel Ikmal, Mr. Daniel Ikmal.
Yes.
So, can you give your opinion or your knowledge about this statement or topic?
Okay, thank you, Mr. Akmal. Okay, firstly, I will explain about the OSH on the business management. The objective of the objective of the OSHE 1994 is to secure the safety and health of all the welfare of all persons in the world, especially the employer and the employee, and to protect the person at the place of the work. Other than that, another objective are to promote a suitable safe workplace to the employee and enable previous legislation to be replaced by regulations and approved industry code of practice operate in combination of OSH Act 1994. Okay, OSH Act ni it is practicable, mean it's having regard the severity of the hazard, or raise knowledge about the hazard, or risk and any way of removing and mitigate the hazard or risk. The example of manufacturing on business management in OSHA at 1994 application is manufacturing of food beverage, tobacco, textile wearing apparel, and leather industry, the manufacturer chemical, non-metal industry, basic method industry, metal machinery and equipment. The construction industry, the OSHE in 1994, used the Act of 520 General Contract, including the civil engineering and special trade contracting in the agriculture, forestry and fishing ocean at 1994 include in Perry Farm palm oil plantation. Poultry farming in the fishing disport industry of occupation and catching fish ocean and coastal fishing in the utilities include the electricity supply, the current, especially used in the source of power. Meanwhile, in the gas industry supply, combustible gas substances such as natural gas, coal, gas and fuel, the sanitary service related to the public health, especially general hygiene and removal of human waste through a sewage system, transport, storage and communication to carry people or goods of one place to another place. For the example, lorry and bus. Transportation also include in OSHE Act 1994 for the retail trade buying on and selling of goods in small amount directly to customer. Food house, drink, tobacco, hotel and restaurant are a building of commercial establishment when people buy their lodging meals and sometimes facilities or service. OSHE at 1994 did not include in the army, and this act also not applied to the offshore installation and as included in premise prevailing law. If there any complete inconsistency between the provision of this act and its regulation or any other law pertain to occupational safety and hit the provision of the act, its regulation shall prevail. This means the prevailing law is to apply the law in the company. Lastly, the requirement to establish safety and health committee also different from the occupational safety and health. FMA Effective Machinery Act is the employer that should establish safety and health committee at the place of work. If there are 40 or more person employer, FITRI machinery. Regulation require only 50 or more person. Other than that, the interpretation of the OSHE 1994, a contract or service between two persons where the one agreed to employ another as an employee and provide service for the company, and the other is the employer who can pay the employee to work with them. For the example, is a postman. Postmen were at the post office and the company need to provide them a motorcycle and lorry or the other transportation for the postman to work safely. Another example are pizza delivery. The company need of visa need to provide the employee with a safe transportation for them to work. The premise and the employer also need to provide the secure and safe premise for the employee to work. I think that's all for OSHE on the business management that include salient features because it is features that we can see every day and we can see it all of company that use it. Thank you.
All right. Welcome, Sir Daniel Ikmal. So, what can conclusion that I can make from Mr. Daniel Haikal is the OSH is related to Section 28 from Act 1994, which is case of illness and case of changes in process substance, which is may cause a risk of injury. The employer need to do something about it to the employee to be responsible to the employee safety. So usually when we were working, we have the employer and employee. So we will be having two type of communication. This is why we will go into the provision to the salient proposition of the OSH 1994. So which is will be explained more by panel 3, Mr. Abdul MOHAIMIN AFIQ bin SHAMSUL AMRI. So sir.
Alright, so I'm gonna thank you for the moderator.
Oh, welcome.
Welcome. And I will continue on the forum. Okay, so Assalamualaikum, my name is Afiq, and today I'm gonna explain more on what is salient provision. So before we start, I would like to expose to you guys about what is the meanings and what does it do. Okay, so first of all, this is called salient provision in which no reference is made to continue the past practical or to guarantee the local working condition. This means that there is no any agreement or arrangement assignment that has been made will not be exposed to the public and for the other from the project. So that's why it is called as salient provisions. Okay. But if a contract is silent provision and assignments, what kind of assignments that can do or make the salient provision contract to proceed is most to redaction permit the free transferable of contract if the contract is salient on assignment. Okay. So is there any desire to restrict assignment and enter assignment class must be included, which means if there is an project of industry regarding the factory that may cause any illegal damage to the environment, a salient provision agreement is required. So the good things about this salient provision is that the provision needs two sides of agreement. All right. So first of all, before we can explain more about the contracts that can be assigned and cannot be assigned, there are types of assignments that can include the salient provision, which are cannot. There is personal service, contract partnership agreement, and patent license and such, and other more. Some may ask that, can you assign an agreement without consent? Okay, these parts will be explained more by my next candidates, Mr. Farhan. Thank you.
Hello. Okay, thank you to Abdul. So just like Abdul said, we need sorry. So just like Abdul said, we need to both part agreement to proceed the silent provision. Generally speaking, contract it can be freely assigned to third party, but this contract cannot be assigned to anyone without recent consent from both parties, even though whenever there is means conduct in this agreement. So you can assign your right to sue, which is the common law provision against the assignee to sue you under her name to enforce any obligation that widely obligate the legitimation. This is the status in many jurisdictions. So enable that the sign to suit the under their name to provide any death or thus not to face any lawyer, not to face any lawyer life, though this is called silent provision. Silent does not mean true if you do not voice any objection to something. This is assumed that you support it, but silent means consent. Make sure you speak out whichever that you disagree on something, because for many people silent means consensus, which is silent is agreeable, that can contribute to miscommunication and is understandable in making any agreement. Okay. This is because why silent is not considered to be a statement notice to the obligor. Is not required and obligate re, rende, who render performance, which is the person that give an assignment to anyone without notice of assignment, which is that performance of contract is to be rendered. Now to the assignment, that means an unexpected assignment that given to the assignment that given to staff without any proper notice or early notice. Obviously, that any person that cannot keep eye on the consideration of their workers they receive are not actually eligible to work as in that department. So as you all know, there is from this the so there is the right how to see which person or right can be assigned with this the right or benefit being assigned. It may be paid with the contractual consideration such as money. The right may be vast or contiguous and may include an equitable interest. So that's what is silent probation is, an agreement between two parties without expose any accident or incident to the outside world. So that's actually about silent probation. So thank you. I give to Mr. Akmal.
Oh, thank you, sir. Okay, thank you to Mr. MOHAMIN and Mr. Farhan. So from there we know that Occupational Safety and Health Act in Malaysia and its salient feature. So we do a discussion with board of party with of the employer and every self-employed person to prepare and be appropriate revise a right statement of his general policy with respect to the safety, health and work safety of his employee. Lastly, every employer should consult the safety and health commit to the making a maintenance of arrangement which is will enable him and his employee to cooperate incorporating developing measure to ensure the safety and health at the place of work and checking the effectiveness of such as measure. So I would like to I would like to take this opportunity to thank each of the panel Thank you to Mr. Muhammad Nur Fitri, Zuhair bin AZMAN. Thank you, sir. Sir?
Welcome.
Oh, okay.
You're
Sir, still good?
good. I'm fine.
Alright. So, Mr. Muhammad Daniel Ikmal bin Muhammad Nazri. Okay, good, sir. Alright.
Still good, still good.
So, no, still good. Don't be serious and be chill, right? Okay. And thank you, Mr. Abdul Muhammad AFIQ bin SHAMSUL AMRI.
Yes, thank you, sir. Thank you.
Alright, thank you so much for coming today. And Mr. Muhammad FARHAN, IZZUDDIN.
Yeah,
Oh,
thank you.
that you are very handsome, and this is okay for an enlightening and entertaining presentation of rules of OSHE legal requirement in business management and occupational safety and health and in Malaysia is salient feature. Thank you for all to attend today. So I will this forum. Okay. Thank you.